Good afternoon, everyone. It's about time to begin. Distinguished guests, ladies and gentlemen, first of all, I would like to introduce myself. My name is Thanvicha. I am a host for today. On behalf of Thailand Arbitration Center, I would like to extend a very warm welcome to this webinar, the effects and impacts of international sanction on the international arbitration proceeding and the enforcement of awards. We appreciate your time, you taking time off your busy schedule to join us today. This topic is a kick-off session before we start our ADR program at the end of this month. We hope you will find the program we have lined up for you to be fruitful and engaging. And now it's a great pleasure for me to introduce our distinguished panelists of all participants. Our moderator for today, Mr. Chen, partner of Grandall Law Firm, and following with 5 speakers, Mr. William Jia, senior partner at the DeHeng Law Office, Professor Steve Ngo, president of BAIAC, Mr. Stephen Walker from 6 Palm Court, Mr. Joseph England from Quadrant Chambers, and Ms. Supajee Rungroj, Presiding Judge of the Udonthani Provincial Court. Ladies and gentlemen, I think it's about time we got started. If you have any question or clarification, feel free to type in the Q&A box. Thank you. Please, Mr. Chen. Excuse me, sir. Could you turn the mic on?
Okay. Distinguished guest speakers, dear audiences, ladies and gentlemen, good afternoon. Firstly, allow me to extend warm greeting on behalf of Thailand Arbitration Center. I'm Walter Chen, senior partner, senior counsel with Grandall Law Firm China. I'm also member of panel of arbitrators of a number of international arbitration institutions, such as THAC, SIAC, Hong Kong, HKIAC, etc. It is indeed a great honor and pleasure to be invited by THAC as the moderator for the event. I would like to take this opportunity to thank THAC for organizing today's webinar event, and thank you all for joining webinar event. The topic of our session is the effects and the impacts of international sanctions on international arbitration proceedings and the enforcement of arbitral awards. We all know, an undisputed fact we all have noticed today is that when one day we woke up in the morning, we found that we are besieged by the international sanctions of this sort or that, targeting at states, groups, or individuals. Examples of recent sanctions, such as those imposed by the US or Russian-occupied Crimea, China's sanctions against a number of British individuals and entities, including the Essex court chambers. This seems a new normal now. Then, what do we do as legal professionals or as businesses going global, going cross-border? To totally disregard it by turning a blind eye to them, or tread carefully to avoid getting caught up in such sanctions? This is the theme we together are going to explore within the next short 90 minutes. As moderator, I hope that after panel discussion and navigation of the topics, we are at the end crystal clear about answers to the below issues. Number one, whether there are legal consequences or effects or impacts upon the international arbitration proceedings and enforcement of arbitral awards? Number two, if yes, what they are, and what do we legal professionals, arbitrators or counsels alike do, and how, and what we can advise for our business clients affected by international sanctions. Number three, the ancillary issue is that if members of the entities being sanctioned can safely avoid or circumvent the international sanction by way of exiting from the entities being sanctioned. The panel of speakers today is composed by 5 distinguished speakers from United Kingdom, Singapore, Thailand, and China. They are Professor Steve Nigel of Singapore, Mr. William Jia Huaiyuan, DeHeng Law Offices, Beijing, Mr. Stephen Walker, QC, 6 Palm Court Chambers, United Kingdom, Ms. Josephine England, Quadrant Chambers, United Kingdom, Judge Supajee, Vice Presiding Judge of the Udonthani Provincial Court, Thailand. And now, something about the protocol of the webinar. Time allocation, number 1. Webinar has altogether 90 minutes until 4:30 local Thailand time or 5:30 Beijing time. 10 minutes at least allocated or should be spent by me, moderator, for brief introduction and moderating. 70, so the remaining 70 minutes for 5 speakers, equally split. Each speaker will be allowed 14 minutes maximum for presentation, so take your time. Finally, 10 minutes will be set aside for Q&A session. The mode of presenting today, after discussion with the guest speakers, we agree that the webinar will take the approach by conducting the presentation in sequence, to do it sequentially by speaker after speaker. And when doing the presentation, speakers may show slides if necessary. And a little alert to all speakers and viewers. In our previous communication, the pre-webinar call, our shared understanding is that the topic we're going to discuss is unavoidably trendy and a bit sensitive. As legal professionals will feel and viewers might appreciate, our discussion should be limited to professional aspect of the topic rather than the political aspect. Simply put, we will only discuss the effects and impacts of international sanction on international arbitration proceedings, whether it is ongoing or in the preliminary stage or in the future, and the effects and impact on enforcement of our arbitral awards. We do not talk about or make comments on the event or merits of the event that give rise to imposition of international sanctions. That is beyond our scope of discussion. If I say if, any deviation from above, I will exercise my power as moderator to intervene. So please forgive me in advance. Thanks. Finally, a brief introduction about the sequence of the speakers to make the presentation. The number 1, the first speaker is Professor Steve Nigel. His topic is impact of sanction on arbitral proceedings. He will sketch out the narrative for the seminar, where he will share how any sanction can impact arbitral hearings and provide the context for the order discussion today. The second, Mr. William Jia, his topic is challenge and removal of sole arbitrator from his ICC experience. He will speak about his actual recent experience with ICC arbitration regarding challenge and the removal of sole arbitrator on basis of China's sanction. Number 3, Stephen Walker, Queen's Court QC. His topic is impact on enforceability on the award. He will speak from practitioner's point of view on how to ensure the enforceability of the award against the backdrop of the sanctions. Essentially, the issues which the practitioner has to deal with and navigate. Number 4, Ms. Josephine England, public policy. His topic is public policy related issue. He will discuss the arbitral law of public policy to set the legal framework for the issue in play. This is particularly the case in relation to the recognition and enforcement of awards under the New York Convention 1958, of which most major nations are signatories. Number 5, the last and the best. Judge Supajee, the Vice President, presiding judge of the Provincial Court. Her topic is impact of international sanctions on arbitration from the perspective of Thailand. She will basically from the perspective of Thailand, and also she's a judge. She will share something with us from the court judges. Yeah. Now let's kick off the event. Professor Steve Nigger, please. I will remind you a bit, only 40 minutes, so take your time. Also give you a moment to introduce yourself a bit. Okay.
Thank you very much, Walter, for the kind introduction. Good afternoon, good morning, and good afternoon to everyone, wherever you are located. First of all, I would like to thank the organizer, THAC, for having me here today to share some of my thoughts. Above all, I'm also very glad to be part of today's webinar because it is one of those rare occasions, not only that I am in good company with other much more distinguished speakers, but also some of the nicest individuals. I couldn't ask for more. And incidentally, one of the speakers was a Hollywood actor, so please to stay on until the end of the webinar to find out who. Anyway, I will begin this afternoon's talk as a first speaker with the assurance to the rest of my other colleagues that I'll keep my presentation within the allocated time, and I will not be holding the microphone. Hence, I'll be going straight into the substance of my presentation today. Now, most of us here would have heard about sanctions and embargoes, something that we are, of course, increasingly hearing more than before. The core of my presentation today is about the impact of sanctions on the players and parties in arbitration specifically, and put simply, because the fact is, the impact of sanctions in arbitration is a minefield. I would propose to consider the issues in two broad parts. First, the impact on the various roles, that is players and parties, namely the arbitrators and counsels. And whereas secondly, the outcome or impact, that is enforceability of arbitral awards as well as potentially sanctions as well. Now, I've prepared two schematics that seek to sketch out two possible scenarios. The first deals with an arbitrator who is a sanctioned party or individual, or the national of a sanctioned state involving in an arbitral proceedings where one of the parties is from a sanctioning state. One possibility is when a sanctioned arbitrator is contemplated by the parties in a dispute where one of the parties is from the sanctioning state. If both parties, one from a sanctioning state, proceeds with the arbitration involving a sanctioned arbitrator, this is likely to give rise to a variety of issues. For instance, the rendered award may eventually be unenforceable in the jurisdiction of the party from a sanctioning state, or the possibility of secondary sanction or penalty against a party or the parties for continuing with the arbitral proceedings. Also, if one party proceeds with the arbitration under a sanctioned arbitrator, where the other has boycotted it, obviously, then this would give rise to the fundamental question of the right of equal treatment and the right to be heard, as these are essential principles of arbitral due process. A party that needs to comply with a sanction in his home country will have the right to say that he should not be placed in certain harm's way. The absence of a party in the proceedings, of course, gives rise to the question of whether this party has been given the full opportunity of presenting its case. Of course, a sacrosanct element in arbitration and among others provided under the model law and New York Convention. Enforceability of an award arising from such a proceeding almost inevitably gives rise to the enforcement of enforcement complications. Incidentally, the question of sanctioned arbitrator is also not a new issue. THAC, for instance, in the ICC's note to parties and tribunals on ICC compliance, a document published on 29 September 2017. Among others, the guide states that, which I quote, when completing their banking instructions, arbitrators should ensure that their bank is able to receive payments from ICC's banks, taking into consideration national and international banking legislation and practices, example, embargo and boycott measures, unquote, paragraph 16. Next is on the Sanctioned Counsel or experts in arbitral proceedings. This is thought to be relatively straightforward because if the counsel is sanctioned and engaged by a party from a sanctioning state, not only that the basic thing is, among others, the payment of fees is encumbered, but the engaging party also risks consequences from breaching the sanction. In this instance, therefore, the engaging party can terminate the counsel relatively easy, as is commonly the case these days with parties changing counsels in the course of an arbitral proceeding. However, the situation might be somewhat more cumbersome should a sanctioned counsel insisted to be retained by a party facing another party from a sanctioning state. Allowing a party to retain a sanctioned individual would tantamount to a guerrilla tactic designed, of course, to apply pressure on the other party that is therefore prevented under the law of his home or place of incorporation to continue to partake in an arbitration process that has become tainted. Therefore, the tribunal has to adopt procedures suitable to the circumstances of the particular case, avoiding unnecessary delay or expense, provide a fair means for the resolution of the matters falling to be determined. This duty, of course, is designed to guard against unnecessary delays and derailment of arbitral proceedings. Now, very briefly, I will provide an overview of the consequences of going against the sanction. My other esteemed colleagues, of course, today will deal with them more. I'll just give a very short introduction or overview of this. I would suggest that we look at it in two parts. First, the consequences of setting aside and non-enforceability, and secondly, consequences from the violation of the sanction. Setting aside and non-enforceability on grounds of public policy remains top on the list, and I believe the rest of my speakers will also be covering that later on. And turning, of course, to the conduct of arbitration amid sanction, I am suggesting three key considerations. The first is permission, and for instance, in the context of the United States, involvement of sanctioned persons or entities need to be licensed by OFAC or the Office of Foreign Asset Control. Most pertinently, a case heard before the Southern District of New York in the case of United Media and Fox Media in 2017, it deals with the question of license from OFAC to engage in arbitration with a sanctioned person, and that arbitration proceedings are covered by the sanction in that US persons were prohibited from engaging in any transactions with respect to arbitration absent OFAC authorization. In this case, there was considerable difficulty incurred by the parties due to the involvement of the sanctioned party, and the proceedings were repeatedly interrupted by sanction concerns. Subsequently, an attempt was made to vacate the award on grounds of public policy due to, among others, the legality of the proceedings, due to the arbitrator and parties' participation arising from a sanction status, but whether or not also the authorization was granted by OFAC. This case certainly demonstrates the difficulties that could be faced in arbitration involving sanctioned persons or entities. I have also further suggested that due diligence and clarifications ought to be sought, particularly when the sanctioning state does not have the equivalent of OFAC. This is to clarify what is the extent of the sanction and the prohibitions still in place. Of course, an analogy would be like in Singapore's traffic rules, where U-turn is by default not permissible unless there is a sign providing for it. So I think it's very important to seek clarification when in doubt. And of course, as a matter of recent development, this year a sanction was imposed by the Ministry of Foreign Affairs, China, on Essex Court Chambers as set best in London. I have actually written an article in relation to this topic, so feel free to look up this article published by APREC in April 2021. Very quickly, I shall now close, but I will propose with more questions. I think that deserves more contemplation and also further inquiries. This is particularly so because arbitration is now the mainstream method of dispute resolution for international trade. And of course, sanctions and embargoes, as we know by now, have a vast impact on commerce and economics. Firstly, how are sanctions involving the arbitrators and counsels be dealt with? Are there ways to circumvent or loosen the sanctions? For instance, would a sanctioned person become unencumbered simply by changing nationality, perhaps or even moving to another unsanctioned country? Also, on the point of piercing of corporate veil, this comes to mind. Companies are regarded as separate legal entities per se, as per the Solomon principle. However, the same way may not apply to certain professional entities. For instance, one that is not regarded as a separate legal entity. One such example would be barristers' chambers. A sanction on an organization that is not a separate entity raises the question of the enduring effect of the sanction attaching itself to a person or persons tainted by it. Finally, it is also worthwhile examining the questions of the impact of sanctions involving the parties. Hitherto, we do not have many cases to turn to, particularly the impact of sanctions affecting arbitrations involving private parties. But nevertheless, some potentially novel points for further research and considerations to present themselves under these circumstances. For instance, can two unsanctioned parties enforce an award in a sanctioned state where the arbitral proceedings involve a sanctioned individual? Would the award be enforceable? Also, what if the parties go into an arbitration with one party knowing that sanctioned persons are involved, all with the tactical view of derailing the proceedings or as a sort of insurance, so to speak, to later challenge the enforcement should it loses? And of course, whether such a party can get away with this. With that, I'm keeping within the time of 40 minutes. Walter should be pleased with that. And I will now hand over the virtual microphone back to the moderator and subsequent speaker. Thank you very much for your attention and to stay well. And I look forward to having further discussion during the Q&A session. Thank you very much.
And thank you, Steve, Professor Steve. It's very illuminating, informative, and just sketch out the general framework. But may I ask a question? A little bit, because you says a lot about the arbitrators, the counsel, or mainly most, the legal professionals. Any advice when facing the international sanctions? Any advice for the businesses going global? It seems that you have never mentioned that aspect of, Could you?
Well, I think, Walter, insofar when you mention business, I would construe that as, I would interpret it as the users of arbitration.
Yes.
So I think in terms of the users of arbitration, before arbitration occurs, we are talking about two parties or more parties coming together to do business with an aim of achieving their business and commercial objectives. And disputes would be something that is way behind, at the back of your mind, something that is not at all contemplated or considered. In fact, maybe even considered as inauspicious having to deal with it now. But of course, last disputes are not avoidable. And when they happen, they happen. And I guess that puts things really in a very difficult situation because although we are not seeing sanctions and embargoes happening on a daily basis, but when it happens, then I suppose business people and users of arbitration would need to pay attention. They would be in a better position themselves to understand that and to know that because they know who they are doing business with, in what territory, where do they put their investment, where their risks are. And of course, very little can be done after they enter into a business contract or started a business relationship and something of that nature happens. But again, this is not something new. And so my quick advice would be that this is where it is essential for parties to turn to their trusted counsels who are very experienced as regards matter involving international trade, because they will be in a better position to do that. So I suppose that would be the short answer to it, and I'm sure there are more to it because there are potentially other permutations to that. As I have said, business people will know what are their risks typically. They know where they are doing business and so forth. So it's not really necessarily an easy question to answer.
Yes, certainly. You know that my personal experience as an arbitrator at a certain international arbitration institution, because one party got sanctioned, and the file counterclaim to the existing petition existing arbitration, and because due to the sanction, they cannot make the payment, and they struck out by the tribunal. My personal experience. So really, it impacts the proceedings. So that somehow that's why as a counsel, we sometimes represent the client, and we need to ask the. I think that among those audiences might be some business executives or whatever. They might be interested in this answer. Okay, next speaker is Mr. William Jia. He's recently, successfully challenged and removed a sole arbitrator in the ICC case. So please share it with us and with the audiences, subject to any confidentiality you observe. Okay, please. Mr. Jia, could you unmute your Mr. Jia?
Sorry about it. Sorry. Yeah. Okay. Is it okay?
Yeah, fine.
Okay. It's dear Mr. Moderator, and there are the distinguished speakers and the audience. It's my honor and privilege to deliver my presentation in such a big event. Actually, my presentation has got 7 points, and we are going to talk about the impact on international arbitration. But each of them is pretty simple and brief, and I will finish my presentation within 40 minutes as required. Yeah. So I'm from DeHeng offices. I'm based at both office in Dubai and Beijing. Yeah, let's move on the content of my presentation. Actually, we've got, as I mentioned, I've got 7 points. The first is the purpose of this presentation, and the sanction imposed by the Chinese government, and the legal basis to the challenge, and Chinese firm and Chinese companies exposed to penalty, the non-complaint to arbitrator, and also the academic interpretation to sanction, and the solution to the Chinese companies and the Chinese firms for avoidance of risk. So let's move on the first point. Sorry, I think it's okay. Before we go to other details, I'd like to make it clear the purpose of the presentation as our moderator guided. So that this presentation does not discuss any political elements, and nor the reasons for the sanction imposed by the Chinese government. And this presentation does not analyze the sanction imposed either at the international law level or at domestic law level. We only discuss the consequence of the sanction on international arbitrations. So it's to talk about this issue, I've got to introduce a little bit of background of this presentation, because we have got one case, one arbitration in ICC London. On the 26th March 2021, suddenly one sanction was announced by the Chinese government. In terms of the content, it says Chinese citizens and institutions will be prohibited from doing business with them. But the Chinese government does not give a further explanation or interpretation on the definition of doing business. So we went for the Oxford Dictionary, and the business, trade, the activity of making and buying, selling, or supplying goods or service for money. So it's on our understanding, it's the definition of the doing business. So after the announcement, so this the content of the sanction was published on the website of the Chinese Foreign Ministry, and also it was reported by many medias and newspapers. And later on, the legal opinion issued by the Access Court Chamber was removed from its website. That's the background. We challenged the arbitrator. So we filed and we applied for the challenge to the arbitrator on the legal basis. That means one is the decree, and we understand, we believe it is legally effective and binding on Chinese citizens and companies in China. And also based on the Article 5 of New York Convention, and our other distinguished speaker will talk about the public policies in relation to the New York Convention. I won't take more time to discuss it. So it's for the Chinese firm, for the Chinese lawyer or the Chinese company failing to comply with the sanction announced, and if they were to participate in such an arbitration, definitely it will be exposed to the penalty by the government. And the law firm can be sued for negligence by client. And in addition, if the Chinese client has to pay penalties to the Chinese government for being in breach of sanctions, the client can seek a compensation against the law firm for its negligence. So the risks are there and quite serious, actually. So one issue I'd like to make it clear, and I'd like to make it a special declaration, that is that we have no complaint about the solo arbitrator and his or her conduct of the arbitration. We bear the solo arbitrator no ill will whatsoever. So on the contrary, we respect the arbitrator very much and are satisfied with the arbitrator in all aspects due to the arbitrator's professional in the conduct of the proceeding. And after several rounds communication between us and the arbitrator through the ICC, and finally the ICC accepted our application and made the decision to remove the sole arbitrator and appointed a new arbitrator instead. So that's the background. So what I like to speak more about the sanction on academic level. That is, as Mr. Steve mentioned, there is no legal status to embarrass the chamber. Therefore, so that any person who was a member of ECC on 26 March 2021 so still remain a sanctioned individual until the sanction is lifted by the Chinese government. So that's a reality. Finally, I'd like to see, so the solution to Chinese companies and the Chinese firms for avoidance of the risk, I would say is before the sanction is lifted, as a Chinese firm, as a Chinese counsel and a Chinese company, we should always ask the potential arbitrators and the barristers if they were member of the ECC on the 26th March 2021. I think it's our responsibility. And further, we have got to file in a challenge if the arbitrator of the tribunal is a sanctioned individual, even if she or he is now at different chambers. So this is the points we're talking about in question. If anyone has got different thoughts and to discuss with us, I suppose you are most welcome to do so, and we are also willing to listen to you. So that's my today's presentation. Thank you very much indeed for your patience. Thank you very much.
Okay, thank you, William. And so far as I know, this is the first such case after the sanction by the Chinese government. I'm a little bit curious about what motivates you to launch an application with the ICC. Basically, the risks of negligence on part of the lawyers, or are they all pressurized by the client to file such an application? One question.
Yeah, thank you very much for your question. This sanction announcement was on 26th, but actually we submitted our application form on 29 very quickly. So we actually considered all the aspects as mentioned in my presentation. Also, you mentioned. So first of all, we could be exposed to the penalty by the Chinese government because we are Chinese firm, we are Chinese counsel, we are Chinese company. And the second is the negligence. Inevitably, it's if we did not file this application, yes, it's our negligence. And third is if there's any sanction, any penalty imposed by the Chinese government on our client, in turn, our client may claim and make a claim against us for our negligence. So that's yeah. We consider all the aspects. And we decided to submit to the decision. Yeah, thank you.
Okay, but basically, just the legal exposure. You feel that the large legal exposure, so initiated such application after your initiative, not prompted by the client, right? And another question. I'm curious also about the ICC decision. What basis on such decision? Just now you mentioned there's nothing wrong. You do not, you said for the sole arbitrator, it seems that his conduct is all right, and you are fine with that simply because of the sanction. So I'm curious about the decision because it's maybe you keep confidential, and any basis by ICC in his decision, or doesn't mention that simply. Okay.
No, it's for the confidential issues. I'm not allowed to disclose so many information, but
okay.
Yes, as I mentioned in my presentation, and we are satisfied with the arbitrator in all aspects, and in terms of his professional, and in terms of his conduct. That's fine, and there's nothing related to complaint against this sole arbitrator, but the sanction is there. Okay. We need to follow it up. Okay. Yeah. So the ICC understood our situation and then accepted our submission.
Okay. Finally, another the most important question is that your point about ECC, being sanctioned by Chinese government, all these members of the ECC, as of 26th of March, all members of ECC SX court chambers should be sanctioned, regardless the exiting by way of exiting from the chambers. So that's your point, right?
Yeah, yes, you are right. Because as I mentioned in the presentation, And the Chinese government does not give further explanation or interpretation on the scope of the sanction on the individuals. But the reality is, so because the ECC is not legal, has not a legal status, and it consists of the self-employed barrister or QCs, and in my understanding, that should be on all the members, and even the member left the chamber, and otherwise the sanction would be a little bit a mockery.
Okay. That's good. That's a good point. And unless and until the sanction is lifted by Chinese government, they should be sanctioned, whether they stay there or they go out of the chambers. Okay. Thank you. And next.
Thank you very much. Yeah.
Thank you very much. Very clear on these. Next speaker, Mr. Stephen Walker, QC, please.
Well, thank you very much. Thank you very much, Walter, for that kind introduction. Ladies and gentlemen, a very good afternoon to you all from Perth, Western Australia. My name is Stephen Walker, QC. I'm a British Queen's Counsel with a very international arbitration practice. My interest for this area developed many years ago when I worked for the international law firm Allen & Overy. Since then, I specialize in international commercial disputes involving construction and engineering, oil and gas, mining, as well as corporate and financial disputes, where I act as counsel or arbitrator. My main office is in London, but I work extensively in Europe, the Gulf, and where I am at the moment, Asia Pacific. I usually live in Kuala Lumpur, Malaysia, and Perth, Western Australia, and it is a great pleasure to speak to you all today. Ladies and gentlemen, the world is seeing the increasing imposition of economic sanctions and financial penalties applied by one or more countries against a targeted state, group, or individuals. These instruments of foreign policy are designed to apply maximum economic pressure to obtain a desired financial or political outcome. In a sea full of sanctions, we arbitration lawyers have to navigate a course to avoid any hurdles or pitfalls that would put in jeopardy the successful enforcement of the award. This is our prime objective as counsel. The impact of sanctions in international arbitration is certainly not a new issue. However, the increase in the scale and type of sanction imposed on potential parties, arbitrators, and lawyers involved in international arbitration proceedings have raised many questions and generated significant uncertainty over the proceedings themselves, and more importantly, over the easy enforceability of awards. These days, sanctions are involving the larger economies of the world, and there is simply more scope for more of us to be impacted by one sanction or another in the course of our practice. The impact of sanctions on international arbitration has been studied and discussed for many years, notably in relation to sanctions against Russia, Iraq, Libya, and Iran. It's worth taking a moment to have a look at a couple of examples of the sanctions imposed, whether these are implemented sanctions imposed by the United Nations or the European Union, or sanctions imposed unilaterally. Economic measures imposed by states unilaterally do not generate any binding obligation in the target state, in contrast with sanctions imposed by the UN. The Security Council is vested with the power to adopt the relevant measures. Sanctions imposed by the UN Security Council, according to Articles 25 and 41 of the UN Charter, create international legal obligations for every UN member state. In fact, a breach of sanctions under the UN Charter can amount to a violation of public policy under Article 5 of the New York Convention. Where sanctions are adopted by regional international organizations, for example, the EU, or by a single state, the provisions are binding only on natural legal persons under the jurisdiction of the state enacting the sanctions. Correctly identifying those bound to comply may present difficulties. Sanctions are territorial. They are informed by political realities, and one tends to see an increase in the use of unilateral sanctions. In the case of the Ukrainian crisis, due to Russia's Security Council permanent member status, multilateral sanctions against Russia were simply not possible. The application of economic sanctions imposed, for example, unilaterally by the EU in 2014 upon Russia in relation to the situation in Ukraine, are territorial. They apply within the territory of the EU to any person who is a national of a member state or incorporated under the law of a member state, or to any legal person in respect of business done within the EU. Other entities not listed in the regulation have no obligation to adhere to the restrictions it imposes. These considerations can indeed influence parties opting for arbitration instead of court proceedings, as well as the selection of a particular arbitration venue, which may be used to try and avoid the application of sanctions. Of course, the tribunal will have different considerations, depending on whether the sanctions arise from the substantive law governing the dispute, or the state where the arbitration is seated, or a third state with sufficiently close connection to the dispute. Although arbitral tribunals may have considerable freedom in deciding whether to give effect to, for example, EU economic sanctions, there is an inherent uncertainty in relation to the claim for uniform application, and the choice of arbitration does not necessarily exclude their application where EU sanctions constitute public policy of the member states. The potential for the annulment of the arbitral award by a competent court in an EU member state, or the denial of the recognition and enforcement of the arbitral award in the EU, may render the choice of arbitration moot. The same can indeed be said for sanctions imposed unilaterally, where these are expressed in public policy terms. It is important to recall that arbitration inevitably involves a personal dimension. Arbitrators, counsel, and the administrative personnel of the arbitral institutions are private individuals who must comply with the laws of the state of their residence and may indeed face significant administrative or even criminal penalties for non-compliance. Therefore, sanctions will have a significant impact on proceedings if they relate to individuals acting as an arbitrator, acting as counsel in an arbitration, or acting as a legal expert in arbitration proceedings. At the forefront of any good arbitrator's mind is to do all they can to ensure an enforceable award at the end of the day. From an arbitrator's perspective, deciding on the impact and effect of a set of sanctions, their scope and applicability, any inconsistent laws or regulations, any overriding mandatory rules in any jurisdiction can present real complexity. It can also present real uncertainty. A tribunal will usually have to consider the parallel existence of various applicable laws, the substantive law applicable to the commercial relations between the parties, the lex arbitrari, the procedural law of the arbitration, the laws of any state where the winning party might seek enforcement of any arbitral award, other laws with which the dispute has a significant connection, and how any sanctions, their scope and applicability, impact on all of the above. A very complex task indeed. And ladies and gentlemen, complexity and certainty do not often sit very comfortably together. The appointment of arbitrators is principally a personal appointment, where the characteristics of the individual play a significant role in the appointment process. A sanctioned individual would cause concern over the legitimacy of the proceedings and the enforceability of the ultimate award. Most likely, sanctioned arbitrators will not be appointed, or if already appointed, they will be subject to challenge, and if necessary, if those challenges are unsuccessful, they will be subject to further challenges post-award in the seat and in the place of enforcement. The primary purpose of arbitration is to obtain a good quality award, which you can easily and quickly enforce. Anything that challenges this fundamental principle of arbitration, which is really the backbone of the success of international arbitration, must be prevented at all costs. Inevitably, much of the current anxiety around the application of sanctions in international arbitration arises from the possibility that an award is tainted by the sanction and might be set aside or its enforcement ultimately refused by competent national courts. The grounds for intervention of the court are limited. These are provided in the New York Convention, and we can read these for ourselves. There is little current guidance as to whether economic sanctions constitute part of the public policy of an enforcing state, and if so, whether they outweigh the enforcing state's policy in favor of the finality and enforceability of the arbitral awards. It is worthy of note that the International Chamber of the Paris Court of Appeal last year dealt with the impact of US, UN, and EU economic international sanctions against Iran on the validity of an arbitral award in a decision dated the 3rd of June 2020. That's a case of SAT against N, where the court rejected the application to set aside the award. In distinguishing between sanctions, the court held that unilateral sanctions taken by US authorities against Iran could not be regarded as an expression of an international consensus, since the extraterritorial scope of those sanctions is disputed or was disputed by both the French and EU authorities. The French court found that the unilateral sanctions did not fall under the qualification of French international public policy. The case does draw a clear distinction between unilateral sanctions and those imposed by the UN and Security Council resolutions when it comes to considerations of public policy. However, the uncertainty surrounding the impact of sanctions more broadly on the validity of the award remains. Further issues may also arise due to the blocking or freezing of any payments to or from a sanctioned entity, potentially preventing the payment of arbitration fees, the costs of counsel, of witnesses, and most worryingly of all, potentially preventing payments as a consequence of the arbitration award itself. The increase in US sanctions, including against Russia, the EU sanctions, including against Chinese officials, and China's counter-sanctions against a number of British individuals and entities have created hurdles which we arbitration practitioners have to overcome in order to ensure the enforceability of the award. One of the most significant sanction developments is the impact of sanctions against members of the bar and sets of barristers' chambers who may be participating in existing or future arbitrations, either as counsel or as arbitrator. In the UK, unlike a law firm, which is a registered firm, has its own legal personality, all of its own, a barrister's chambers has no legal personality of its own. A barrister's chambers is simply a collection of individual self-employed barristers operating under one brand. The sanction imposed by China on Essex Court Chambers on the 26th of March 2021, the 263 sanction, would in my view have to be read as a sanction that has been imposed on all barristers who were members of that chambers on the 26th of March 2021, as these are sanctioned individuals. According to the 263 sanctions, Chinese citizens and institutions are legally prohibited from doing business with sanctioned individuals. This means that Chinese law firms are not entitled to appoint any sanctioned individual as arbitrator or as counsel. To do so would mean that both the Chinese law firm as well as its Chinese client would be in breach of the 263 sanction. There is also an additional concern, ladies and gentlemen. If any of us propose a sanctioned individual to act as arbitrator or counsel, and problems arise in the arbitration or when we enforce the award, as a result of those sanctions, are we professionally negligent in making that suggestion in the first place? Certainly something to consider. Non-Chinese law firms and non-Chinese leading counsel would also need to be very careful not to engage a sanctioned individual, as they could find themselves being sued, as I've said, for professional negligence, if the award can be attacked or rendered unenforceable for being a breach of the 263 sanction. In addition to being exposed and potentially having to compensate the Chinese client in the event that the Chinese client has to pay, say, further penalties to the Chinese government for being in breach of sanctions, that Chinese client may also seek indemnification from the law firm for negligence in allowing a sanctioned individual to participate in the proceedings in the first place. It is therefore important to both Chinese as well as non-Chinese law firms to protect themselves by seeking a written confirmation from a potential arbitrator or lead counsel at the outset that he or she was not a member of Essex Court Chambers, say on the 26th of March 2021. If so, he or she still remains, in my view, a sanctioned individual until the sanction is lifted by the Chinese government. So sanctions create legal uncertainty, legal unpredictability, and this must be avoided. In order to ensure the enforceability of any award, it can be simply expressed. Those subject to sanctions cannot freely participate in arbitrations, whether as counsel or as arbitrator or in the other capacities I have mentioned, until those sanctions are lifted. Thankfully, ladies and gentlemen, the answer to that question is for the politicians, not for the lawyers. Thank you very much, ladies and gentlemen. It's been a pleasure speaking with you all. And also, I should like to thank the Thailand Arbitration Center for hosting this event.
Okay, thank you, Stephen Walker. I totally agree with your point that the sanction creates uncertainty and legal unpredictability, and also the legal exposure for our legal professionals. And just now, other point is that because the chamber, because you are Queen's Counsel, the barrister, you from also you practice from the chambers, right? And not all of us understand the function of chambers. Just now you mentioned that for chambers there's no legal status. Any sanction targeting at chambers, in substance targeting at the barristers. So the conclusion is that anyone after being sanctioned, the chambers being sanctioned, try to escape or exit by becoming a barrister of another chamber, or or practice other way, then should be sanctioned, right?
Well, I think that's certainly the impact of the sanction, because it's always very difficult to explain to people outside of the UK what a chambers is and how it operates, because it is quite confusing, because you have a brand name which is usually an unincorporated association, comprising of a group of people, 30, 40, maybe even 50 people, that don't work together. They're self-employed. They're not conducting a business with the view to profit. They're all self-employed individual contractors, and they share a little bit or a lot, depending on your chambers, I suppose, of their fees to pay for things like accommodation, meeting rooms, marketing, clerking, some administrative support. But it's a very loose relationship. It's not that much different from a serviced office in one view. So, and I think that's the thing, because I think when people see a barrister's chambers, they assume that you know, it's like a law firm. You know, we're all in there, we're all working together, we're all sharing profits at the end of the day, and it's simply not like that. So I think I agree with you, Walter, that where you have a group of people that are part of effectively it's a cooperative of sorts. That's really what it is. And there is a sanction like this, it would seem to apply to, you're right, the individual members. Let me take a good example. COVID, it's affecting all of our lives, COVID. Think of a cruise ship. Think of a cruise ship that arrives here in Australia, and everyone or a few people has COVID. If they put a quarantine order on that ship today, that quarantine will apply to every single passenger on that ship. That's the best example I can think of.
Yeah, good example. Great example. Thank you very much. And the next, Joseph, England, and I only can give you 10 minutes, so please limit yourself because only have half an hour. And okay, please.
Yes, but thank you. Good afternoon, everyone, or good morning from London. I'm also delighted to be here today, and amongst such excellent other speakers and the moderator and our wonderful organisers. My background briefly is that I am also a barrister in Quadrant chambers in London. I specialise in international arbitration and commercial litigation. Like Stephen Walker, Queen's Counsel, I also started life at Allen & Overy before becoming a barrister. I've worked as judicial assistant to Lord Sanction in the Supreme Court and have appeared as counsel in the Supreme Court, as well as the Court of Appeal, the High Court and other courts and tribunals. I've spent a lot of my career fighting ICC and other institutional oil and gas and construction and engineering arbitrations, and I have appeared as an expert and advocate in foreign courts as well as the English courts in respect of the enforcement of awards, most recently for the government of India, resisting enforcement on grounds of public policy, which brings me neatly to the focus of my talk with you today. I'd like to touch on the subject of public policy, which I believe is one of the substantive legal hats on which many of the issues surrounding sanctions may be hung. This is particularly at an enforcement stage where, as has been outlined previously, one is looking to recognise and enforce awards under the New York Convention of 1958, of which most countries are, of course, signatories. Now, in terms of public policy, whilst it seems obvious that a Chinese court would resist the enforcement of an award which was tainted or in some way violated the sanctions, would the same be true of an arbitral award tainted in some way and sought to be enforced in another country? Now, public policy is, of course, not defined in the New York Convention under Article 5(2)(b). It's an amorphous concept. However, there are certain key themes that can be adduced concerning public policy as a defence to enforcement. The first is that the case law shows that it must defend the core values of a legal system such that it can be used as a safety net in exceptional circumstances where it's impossible for a legal system to enforce an award without abandoning the very fundamentals on which that system is based. An often cited quotation is from a US appeal court saying, in terms of public policy, enforcement of a foreign arbitral award may be denied only where enforcement would violate the state's most basic notions of morality and justice. Importantly, and secondly, public policy is viewed from the perspective of the enforcing state. So it's the country you're seeking to enforce in, so not potentially another country. This is important. Thirdly, whilst public policy permits a court to look at the award in terms of its merits for public policy, it's not an opportunity to re-argue the case or overturn a wrong decision. Fourth, violation of an enforcing state's mandatory rules will not necessarily be a breach of public policy. It may be that it is also a breach of public policy, but one doesn't necessarily follow the other. Fifth, the exception is narrowly construed, and it is fair to say that it is rare to succeed on public policy grounds. However, there are instances where it has been successfully applied. Those include excessive interest rates being awarded with regard to the lex fori, the award breaching the mandatory rules of the enforcing state in terms of competition law, consumer protection, foreign exchange regulation, and ban on exports, or being contrary to the core constitutional values of the enforcing state. As Stephen Walker has also pointed out, it's also worth remembering that part of public policy, of course, is to, wherever possible, certainly in England, to enforce arbitration awards. The leading case on public policy and arbitration in England remains the Court of Appeal decision of 2000 in Westacre Investments versus Jugo Imports. This was an arms trading case involving the former Yugoslavia's military sales agency. It raised the issue of whether a Swiss award would be contrary to UK public policy. The defendants said that the underlying contract was to procure influence and to pay bribes to Kuwaiti government officials. The Court of Appeal said that even if that was the case, and even if the award had been obtained by fraud, it could still be enforced. It said that the opportunity was afforded to the defendant to put these matters before the tribunal. In its judgment, the Court of Appeal said that if the contract for bribery was to be performed in England, it would not be enforced as it would be contrary to English domestic public policy. Interestingly, it held that if the contract was to be performed abroad and that performance was contrary to the public policy of that foreign country, in those circumstances, the English court would not enforce the award. I'd also briefly, by way of overview, like to draw your attention to a 2015 study of the International Bar Association on public policy as a defense. 4 key findings. The first is that only the UAE and Australia have a statutory definition of public policy. Second, many countries draw a distinction between domestic and international public policy. Third, courts have difficulty in defining the meaning and scope of public policy, and it's often dealt with very differently by civil and common law jurisdictions. Finally, as I pointed out earlier, it is narrowly construed. It is therefore difficult to predict with any certainty how a particular tribunal or court will approach questions of public policy. In my view, as much as they may not like to, they may ultimately need to engage with the policy behind the sanctions. Whether it be on public policy grounds or other grounds under the New York Convention relating to the tribunal, for example, we can be more certain that there will be various issues, including those you've heard about today, that will arise under sanctions. To my mind, these may also include challenges potentially based on bias towards a Chinese party if an arbitrator is a member or a former member of a chambers which is sanctioned. Second, will it be necessary to look at local law to know who is covered by the sanctions and if they apply? As you've heard today, a barrister's chambers is an unincorporated association, if not a company, and there are quite esoteric English law rules, if English law rules are to apply to as to the sanctions and who they apply to, that those rules are reasonably esoteric. What is the position, as you've asked very wisely, Walter, if a member leaves the chambers halfway through an arbitration, for example, a chambers that's sanctioned? Third, will it be necessary for parties to amend prospectively or retrospectively arbitration agreements to cater for issues such as the easier removal by a Chinese party of an arbitrator than otherwise would be the case? Fourth, should the parties agree specific procedural rules or bespoke terms of reference in the ICC, for example, to cater for these issues? Let me give you an example. We heard earlier of the situation where the ICC court was helpful in replacing the arbitrator. But suppose one party appoints its arbitrator, who's a Chinese party, its counterparty appoints its arbitrator, but then the ICC court, for whatever reason, does not replace the arbitrator that it has chosen, the third chairman arbitrator. Then the Chinese party is placed in a position where it may not be able to continue with the arbitration because it's in breach of the sanctions, but then it may also be in breach, for example, of the procedural rules, which are often incorporated into the arbitration agreement itself. Finally, careful local law advice may be needed on the approach of the courts in the seat in which any award is sought to be challenged or enforced. And that should have particular regard, as I hope my speech has pointed out, to public policy. Thank you very much for your attention.
Okay, thank you, Mr. England. One question for you.
Please.
I was told that the public policy defense or grounds is rarely used or can really, be used successfully. Actually, my personal experience with the LMAA case, arbitration case, we successfully used the public policy defense to render shipping building contract, unenforceable. That's really rare. So I was told that it's rarely used. So could you elaborate?
Yes,
a bit?
You're right to say that it is rarely used, but as I pointed out, it's not impossible, as you pointed out, and I have also successfully invoked it. And I think that I pointed out a passage in the leading case that referred to the Westacre case, where it said that if the performance of the contract was illegal in the country where it was supposed to be performed, perhaps that would be a ground for public policy. So you're absolutely right. You shouldn't think that it's an automatic route to set aside an award, but it's possible, and perhaps increasingly possible than it previously has been. You often get this in English law, for example, where sometimes it's not, there is of course a difference, Walter, between substantive public policy and procedural public policy. So many of the arguments people try to frame under public policy are to do with natural justice, and where a party has not been denied, and it's essentially a rerun of another ground of enforcement. But in terms of substantive policy, there may be more fruit than has previously been thought.
Okay, thank you. Next, our beloved judge, please. Could you? Yeah.
Okay, thank you very much. So I have okay. Good afternoon, everyone, and good morning. Someone from the EU country or in the UK. So let me introduce myself first. My name is Supajee Rungroj. I'm a vice presiding judge of the Udonthani Provincial Court. So I'm not staying in Bangkok. I'm very glad to be here today, and thank you THAC and co-hosts for inviting me. So I have to limit myself, right, to 10 minutes, right? Okay, that's fine. Now I would like to talk about the impact of international sanctions on arbitration in Thailand, focusing in Thailand because I'm a judge of Thailand, right? So my presentation is divided into 3 parts. The first one, I would like to provide a basic knowledge of international sanctions. So, and then I would like to talk about the impact on arbitral proceedings, and final, I will talk about the impact on arbitral awards. So it is challenging because I am the last speaker. So maybe somewhere in my presentation, repeat some of your the distinguished speaker before me. So that's okay, that's fine. So let's start with the international sanctions. As you heard from other distinguished speaker that nowadays we have several international sanctions against some countries for several purposes, such as to prevent human rights violations, nuclear weapons, or terrorism, and narcotic drugs, and so on. And the content or the nature of the international sanction may be different, depends on the purpose of the international sanctions. They might be asset funding freeze, not facilitating any transaction of the company or individual of the sanctioned country, or to prohibit individual or entities to enter the sanctioning country, or prohibit to do the business with the entity or the individual of the sanctioned country. So at first glance, there seems impact only on business of the entity or the company of the sanctioned country. But I personally think they can impact on international arbitration through other proceedings that I will talk about this later. How about Thailand? Thailand is free from sanction because Thailand is not the sanctioning country or nor the sanctioned country, but it does not mean that it is not affected or impacted by the international sanction. So let's move on to impact on arbitration proceeding. When I first studied this issue, I was so surprised that the international sanction could impact the arbitral proceeding from the start until the end, or even when the award is rendered. And how sanctions impact the arbitral proceeding depends on the content of the sanctions. As to the first one, the appointment of arbitrator that you have heard from other distinguished speakers. So in case the person or the entity or the company from the sanctioned country and the sanctioning country and the international sanction is relevant to the person or the individual, maybe to prohibit those persons to enter the land or the land of the sanctioning country. So, and if the parties would like to appoint the person whose nationality is the sanctioning country to be an arbitrator, so some difficulties happen because he or she won't travel or arrive at the land of the sanctioning country, right? So, and also in case the tribunal is appointed and the member of the tribunal is the national of the sanctioned country, so it might also happen that maybe it might lead into the withdrawal of his office, or maybe if the parties concerned so much about the impartiality and independence of the arbitrator, so this might lead to the challenge of arbitrator. And so there are troublesome. So, and moreover, the challenge, the tribunal or the court, the competent court, have to decide the challenge, whether the challenge is succeeded or not. It might be the issue in the next stage, that is the enforcement instead of setting aside the award, or the enforcement of the award. That I will talk about that in the next slide. Okay, and after that, about the counsel and representative that you heard from the other distinguished speaker, that the counsel and representative, if the sanction is relevant to prohibit the person from the sanctioning country to do the business with the person who from the sanctioned country, so may be concluded doing business. So if the party pay high to the council or their representative, so it might be sanctioned. Yeah. And about the arbitration institute, so the courts the cost, fee, and expenses. So I would like to skip because the time is too limited. The Arbitration Institute, when the Arbitration Institute act as an appointing authority, they might be reluctant to appoint the person who's from the sanctioned country to avoid troublesome or difficulties later on. Yeah, and so now this difficulty might lead to the case that the parties now are seeking the neutral venue. Maybe the neutral venue is free from sanctions, such as the ASEAN in ASEAN country or Hong Kong and China in some cases, and Thailand is also the neutral venue that can serve the parties to avoid the troublesome from the international sanction. And as far as I'm concerned, the challenge, the court, when the Thai court decide the challenge about nationality of the arbitrator is not so successful, but to avoid the unnecessary pool arbitration proceedings. So I think it should be appoint the neutral persons to be the arbitrator and the counsel or representatives. Apart from those, so the applicable law. So yeah, in some cases, the sanction is relevant to freezing the funding and asset of entity. They might lead to the breach of contract, and the parties who breach the contract always claim that because of the international sanctions, so it constitutes force majeure and frustration. So it is the duty of the tribunal to decide whether the breach of contract constitutes the frustration or the force majeure under the applicable law or not. Is not difficult, right? But what the tribunal decide might be the problem in the next stage, and the party might claim that issue to be to request for set aside the award or to refuse the enforcement of the award in the next stage. So I would like to talk about that next. And and how about the impact on arbitral award? Yeah. After the arbitral award is rendered, if the party confirm the obligation of the award, so there is no problem, even if there is international sanctions during the arbitral proceedings, right? But in contrast, if either party is not satisfied the arbitral award, so two things might happen. The first one is setting aside, and the second one is refusal of enforcement of the award. So if arbitration is seated in Thailand, we have to consider the law, the related law. So now we have Arbitration Act 2002, Article 40 and 44. Article 40 is about setting aside the award, and Article 44 is about the refusal of the enforcement of the award. So because we adopt the model law on international commercial arbitration, so the content in the Article 40 and 44 are quite similar, that those provided in the model law. And Thailand is also a state party of the New York Convention. So the content in Article 44 is quite similar to Article 5 of the New York Convention. What the law say? Okay, and Article 40 and 44, because two articles are quite similar, so I would like to talk about those all together. The possible in this from this as to the international sanctions, so the party might raise the possible grounds to reject the award. That the first one is arbitrability, and the second one is the enforcement of the award would be contrary to the public policy. About the arbitrability, the party may claim that the dispute is not capable to settle by arbitration because there is an international sanctions during the performance of the obligation of the contract. In Thailand, we haven't been dealing with this issue directly, but it could be said that when the court deciding the issue of arbitrability, the court will consider only the type and the content of the contract and the relationship between the parties only. If the contract is commercial or quite commercial, the dispute arising from the contract or that relationship could be settled by arbitration, even if there are some international sanctions during the performance of the contract. So I personally think it could be said that the challenge or the claim about the arbitrability in this issue could not be successful in Thailand. And how about the second one? The enforcement would be contrary to the public policy. If, for example, if the party might claim that the enforcement would be contrary to the public policy because the tribunal ignore the international sanction when deciding who breached or the arbitrary is the nationals of the sanctioned country and so on. So, but by the common understanding, we don't have the exact definition of the policy, the public policy, and what is contrary to the public policy depends on the construal of the court only, and it's varies from state to state. In Thailand, we neither have exact definition of the public policy, and then as far as I'm concerned about the arbitration area, it could be extracted from the judgment of the Supreme Court and the Supreme Administrative Court, which are the competent authority to decide arbitration cases in Thailand. That the enforcement, enforcement would be denied if it violates the basic notion of morality and justice, also impact peace and security of state. So this is quite abstract, and so Thai court, and I would like to say that Thai court will consider on a case-by-case basis and consider the domestic public policy only, not consider international public policy. This means that the foreign or international public policy would not be transformed to be the domestic public policy or public policy of Thailand automatically. But if what is contrary to the foreign public policy
could be contrary to the Thai public policy if it violates the basic notion of morality and justice, and also impact peace and security of state. So to conclude, there are some difficulties in arbitration might happen from the international sanction that I said and others distinguished speakers said. However, I personally think we can handle this, and we are seeking the best solution for this. Thank you very much.
Okay, thank you, Judge. Thank you for sharing with us your unique perception of a Thai judge about this topic. Okay, until this point, we all come through the session, presentation session, and come to the Q&A session. Actually, the timing is up, and I saw a few questions posed. Shall we? I need to ask the viewers to bear with us for maybe 5 minutes. We try to let the panel to address some of the questions, okay? The first question, if any arbitrator or arbitrary institution is sanctioned and one of the parties is incorporated in the country issuing the sanction or at the receiving end of the sanction, will the arbitration proceeding be terminated and a new tribunal or new institution that is not subject to the sanction be required? What happens to the enforceability of the award if the arbitrator or a party or the arbitral institution becomes subject to a sanction after the issuance of the award, but before the enforcement of the award? Mr. Stephen Walker, could you briefly address this?
Yes, well, I think Bernard, we have in our various talks, I think we've largely answered most of your questions. But of course, if a sanction hits after the award has been issued and before enforcement, the issues are still the same as far as I see it. It would still be subject to the sanction. So I hope, Bernard, that together with what we've said answers all your other questions.
Okay, yeah, thank you.
I was just going to say, in terms of the first question that Mr. Lim asked, that there's a choice, isn't there, as to whether you wish to terminate and start again, or whether you wish to just not participate, for example, in the proceedings and let them run. But I would have thought you're right. The option you say in your question to terminate is probably a more realistic one. Sorry, Mr. Chen.
Okay, how about the next question? So I think all these questions, we may spare another session on this question, but we briefly covered it. Another one, what could be the potential path to take for sanctioned entities if they are aggrieved in a contractual relationship and wants to commence arbitration against a non-sanctioned entity in a non-sanctioned state and appoint a non-sanctioned counsel? Mr. England?
What would the essential part of the sanctions if they are aggrieved? I'm just reading the question, sorry.
Okay.
I think the answer would be the same one that we just given. If any of it, I don't know what the rest of the panel think. The potential path to take for the sanctioned entities if they're aggrieved and want to commence arbitration, I think it would be difficult. I don't know if anyone else has an answer to that. I think it would be a difficult path to take.
Okay, Professor Steve, can you share something?
So if I would try to summarize this question pertains to a sanctioned party commencing an arbitration against a non-sanctioned entity in a non-sanctioned state. So when we see the word non-sanctioned here, I think that means it neutralizes it. So it's problem-free, right? But for the sanctioned party, that's a question because so a sanctioned party taking a non-sanctioned party to an arbitration. To begin with, I think there will be a plethora of complications because to participate in arbitration, you've got to put up advanced costs, for instance, like in ICC. You need to engage counsels. You need to be prepared to pay out money and pay out fees. But the thing is, if one party comes from a sanctioned country, clearly that presents a challenge to even begin an arbitration. I'm not suggesting that it's impossible, just that the way I look at it is that we need to break it down into several parts for it to be dealt with rather than from a hypothetical standpoint, but to see how close we can get to a realistic position. So I think that will be my short answer in the interest of time.
Okay, I think we can, I will suggest to THAC to start another session. All those questions, it seems that lots of questions arise. We have to say goodbye at this point. Time flies with all concerted efforts of our distinguished speakers, and we have a, I shall say, robust panel discussion that have covered all aspects, ramifications of the theme topic. Further, we addressed a few questions, not all questions, posed or concerned by viewers. I believe that all of you may appreciate that we have accomplished successfully what we said at the beginning of the webinar. We have all acknowledged or supported the point that yes, the impact of international sanctions upon arbitration proceedings and the enforcement of arbitral award do exist de facto and de jure. In particular, all members of the ASX court chambers on the date 26 March will remain sanctioned, even if they leave by way of exiting from entities sanctioned to circumvent such sanctions until and unless the China government rescinds the sanctions. So finally, again, thank THAC for sponsoring such fantastic webinar. Thank all of you speakers, excellent, illuminating, informative presentation. Thank all of the viewers for your kind support and participation. Looking forward to seeing you again next time. All speakers, shall we say together bye-bye to the audiences? Okay.
Bye. Thank you very much. Bye-bye.
All speakers.
Okay.
And moderator for answering that question and for the guest presentation. It was a pleasure to have you with us. Before we leave, I would like to promote our incoming event. THAC is holding an THAC ADR Week webinar series 2021, which takes place during 29 July until 7 October. The title of this year's series is Managing Dispute in an Uncertain World, Challenges and Opportunities. There are 16 sessions on our program that are waiting for you to explore. You can visit our website to see more detail. More importantly, we would like to thank you all for attending in this webinar. We hope you have learned and enjoyed this webinar. Thank you again very much, everyone.
Okay, thank you.